here we are on chapters 5 and 6 of Prisoners of Freedom. Legal aid NGOs, he says, often opened with the intention of monitoring and defending human rights. So they had a particular kind of mission oriented around human rights in mind, and that would often take on a legalistic quality, as is frequently the case with human rights advocacy. It's often shaped around the legal model. Having said that, though, what they in fact found themselves inundated with were not cases that were straightforwardly about human rights per se, but were labor-related disputes. So then activists' focus on freedoms weren't really good preparation for complaints about working conditions, like pay, arbitrary dismissal, and so on. And the same was true of the Office for the Ombudsman, which the Constitution expected to safeguard human rights, but again, mostly found itself handling cases of labor disputes. On the whole, he says, NGOs were more attractive to workers seeking legal aid because whereas other institutions like the Industrial Relations Court would require some kind of fee, NGOs would, in principle, we'll see it's more complicated than that in some cases, offer free aid and were comparatively nimble in terms of getting cases moving. But Eglund finds, disconcertingly, that the way that legal officials at NGOs would use their, as he puts it, their apparently exclusive legal knowledge to avoid confronting the exploitation that many Malawians endured. While the democratic institutions ushered in progressive labor laws, he finds that this legislation has not actually translated into practice. Significantly then, legal aid officers contribute to this state of affairs. So it's not that they're intending to maintain a particular state of affairs, but that they wind up contributing to it in that they lack commitment to structural transformation of society. And we'll see that in large part this is a repetition of the same kinds of things that Eglund found with civil education, with this emphasis on the sort of abstract autonomous individual, or in these cases, the individualization of cases. He says then that it wasn't a problem of laws. There were labor-friendly laws, but rather the taming of trade unions on the one hand, so that trade unions were not an effective vehicle for generating collective action, and on the other, the reluctance of legal aid officers to make claims on the basis of the available progressive laws in the interest of workers who came to them for assistance and advocacy. The infrequent use of these new labor-friendly laws in the first decade of democracy allowed ruling politicians to congratulate themselves for their rhetoric on labor rights without facing any real challenges. They produced the laws that were friendly to labor, but because the laws were seldom used, they didn't face any confrontation on the basis of those laws. He says, when the ubiquitous discourse on individual freedoms marginalized the systematic promotion of socioeconomic rights, ruling politicians were given a free hand in claiming that the new laws reflected their commitment to their subjects' welfare. In part, This confidence came from an overestimation of the power of the law to produce a social and economic transformation. And this was an assumption that NGOs shared, that in particular the legal aid departments of NGOs. They had this faith that just the existence of laws would be sufficient to produce change. But this confidence also came from a tendency, as I was saying, to individualize claims, which frustrated the sort of collectivization of workers that unions might otherwise do, and from an ineffective implementation of policies, like the regularized review of minimum wage, which either didn't occur or when it did occur, it miscalculated just what was necessary to survive. Labor Solidarity Fund, then, so labor solidarity from one workplace to another, perhaps within an industry or across industry, remained weak and elusive in the democratic era. And this was largely because workers perceived that there were few job opportunities relative to the number of potential workers. And that left them in this kind of precarious position where if they were to create trouble, then they risked just getting laid off because there was a pile of people waiting in the wings to take whatever vacancies opened, and they would not be troublemakers, as it were. And so businesses had this leverage that they could simply threaten workers who said that they were going to organize or who looked like they might organize or protest. This kind of insecurity for workers made it difficult to build labor solidarity. But there remained, and there remained from earlier eras this kind of entrenched sense of authoritarianism. Remember, we are looking at a colonial era characterized by authoritarianism, a post-colonial era that was characterized by an authoritarian government, and only very recently a shift into multi-party democracy. So then that history has kind of embedded itself in a way that allowed employers to respond to workers' protests just at their leisure, however they pleased. And by sort of giving the sense that whatever concessions they decided to give to labor, labor should just gratefully accept. So it meant that there wasn't really much in the way of even-handed negotiation. The patronizing and authoritarian attitudes toward Malawian labor were, in the first decade of democracy, Eglund writes, nowhere more apparent than in businesses run by persons of European and Asian origin. And this in particular with sectors like trade, for example, being dominated by the Asian community. Jobs in other sectors, like the coveted positions as servants to employers of European or Asian origin, relied heavily on personal recommendations, so word of mouth, essentially, being able to secure a recommendation from a previous employer. And this had the obvious implication that as long as it was your character that was the basis of a recommendation, you had to embody the right kind of character for your employer. Again, this stifles any kind of protest. This stifles workers' inclinations to make demands even to which they're legally entitled of their employers. It produced, in a word, docile workers. NGOs offering aid, like the Center for Human Rights and Rehabilitation, often prioritized other things other than um, uh, labor related um, ventures, let's say. So, public awareness and community safety, civic education on human rights and democracy, training and research, and capacity building and networking. And so the emphasis on those things came at the expense of legal aid services. They were sort of an afterthought in a way. The cost of legal expertise is part of the explanation for this. Having qualified people is comparatively expensive, right? But beyond that, at the center, Eglund writes, the commitment to address actual grievances was also rather subdued. To be sure, whatever its founders' radical intentions, the CHRR found itself deeply embedded in the status distinctions and hierarchies of the Malawian society. And this will be a theme that we'll see continue to come up, just as it did in previous chapters, through the rest of the book, how the intentions of human rights advocates were not nothing, but they they would never be enough for people in positions in civic education or in human rights NGOs to really break from the cultural situatedness of their work and from the particular histories they're coming out of, so that that kind of historical cultural dimension to their work tended to be more significant than their intentions or whatever critiques they might have of the government or of employers. Of course, critiques that they would voice, as we've seen previously, in private rather than in public. All of this meant that there remained a rift between clients seeking legal aid in cases of abuse and CHRR lawyers and paralegals who position themselves more as legal professionals than as activists. In the center, legal clinic, in the legal clinic in the center, I should say, officers would draw on medical metaphors to explain why they would not pursue certain aspects of a client's case. And this kind of medical metaphor served three basic functions. First, it provided legal officers with the kind of unchallenged authority medical experts enjoy. Second, he says, it portrayed clients as individuals in one-to-one interaction with the adversaries who had caused their afflictions, employers, rather than as a collection of people whose experiences of abuse stemmed from similar structural problems. So the idea of there being a working class, for example, was not on the radar. And then third, the metaphor made officers' legal instruments seem like medicine, which, when properly administered, assuaged, perhaps even eliminated, clients' grievances. We should not, therefore, find it surprising that legal aid consultations maintained rather than contested social hierarchies. That they might win small concessions from individual employers on behalf of individual clients, but there was nothing like a transformation of the social structure that maintained a large impoverished working class. The combination of lack of funding and low priority that the center gave the legal clinic shifted the burden of pursuing a case onto the client. And so this is why I say that although NGOs seemed attractive to people who wished to pursue labor-related cases because, in principle, they were free, it did not always work out to be the case in practice, because officers were poorly funded themselves. They had little or no travel budget, and so they couldn't pay for the transportation of witnesses who lived outside the capital to come into the capital to testify. That meant that clients were left either to provide for such expenses themselves, which they could seldom afford, or to get written evidence officers required, which again was a hurdle few of them could easily cross. Compounding these problems was a condescending attitude officers tended to adopt. Again, not entirely like the civic educators who we heard about in the previous chapters. To a large extent, this kind of condescending attitude has to do with officers' efforts to protect their status. Again, we've heard something like this already. The unfortunate result is that an officer may become another problem for a client rather than a solution. Eglund explains why officers would sometimes dismiss cases that seemed to have merit. He writes, "It is only when officers' aspirations and challenges are considered as a whole that such apparently erratic procedures can be understood. Much like the civic educators discussed before, legal officers assumed a distinction between themselves and those whom they were expected to assist. The distinction provided them with a professional identity, but a major challenge was to maintain that identity under the conditions of the underfunded legal clinic. It had neither a vehicle nor a computer, and even basic stationery was often scarce. Rather than admitting to clients that meager resources prevented assistance in some cases, officers often preferred to take advantage of clients' less powerful positions and ignorance. The deprivation the officers endured was not allowed to detract from a professional identity." As he pointed out above, one strategy officers would use was to shift the burden of weak cases onto the client, as if it was the client's responsibility to make a case that the officer feared would fail, or that, for problems of funding, the clinic could not adequately defend. In a context in which even mild protest could cost one a job, the legal aid of a human rights NGO could seem to be one of the few trustworthy sites of help. Yet, Eglund writes, some clients discovered hierarchical bureaucratic practices that bore a close resemblance to virtually any other Malawian office. It seemed as if officers provided legal aid less because of their concern for social justice than because of an apparent need to curb claimants' demands. So when facing responses like, "You must help us help you," claimants' poverty can appear to create their predicament rather than a factor harming officers' professional identity. Put otherwise, the officers would go to great lengths to protect their professional identity, sometimes redirecting the burden of pursuing a case back onto the claimant so that it would seem like it was the claimant's shortcomings. It was the unfortunate circumstances in which the claimant lived that were the real obstacle to pursuing a case. Eglund concludes the chapter on these two summary points. Whatever its emancipatory aims, legal aid, no less than civic education, became an answer to educated Malawians' desire to find occupations that brought them status. Elitism reigned even though most legal officers and civic educators shared critical and well-informed views on Malawi's current ills. Such were the entrenched inequalities in their society that any assistance presupposed a clear status distinction toward those deemed to be in need of such attention. Second, and also in line with his description of civic educators, legal aid individualized grievances and claimants expressed. Sorry, so again, this point about not collectivizing, not having a vision that there are structural aspects of um, of socioeconomic relations that afflict the whole swath of Malawian workers, and therefore they require structural solutions rather than individualized case by case solutions. And so this would lead to claimants expressing disillusionment and criticism in private, but never in collective protests. Again, the stakes were just too high to try and collectivize and protest in that way. So now we turn to sort of a case study, with just one individual case that's illustrative of the kinds of problems that a claimant faces when trying to take a case through the legal clinic. It explores the case of Yamikani Chikondi, who worked for Hassan Patel in Patel's shop. Eglund recounts the center's officers declaring their enthusiasm for cases brought against employers of Asian origin, responding with sort of great bravado, saying that they showed them no quarter. So then, if there's a bias on the part of the legal clinic, it's not in favor of Asian employers. There's no sense of collusion with employers simply because there's favoritism toward Asian employers. Sort of the opposite, at least at the level of sentiments. Still, officers' practice did not reflect their stated antipathy for Asian employers. Eglund says, exploited workers brought officers into contact with relatively affluent and influential employers whose corrupt ways could easily make a mockery of legal aid, buying off either the officer or the client. Yet, it was precisely the nature of legal aid as mediation, so not confrontation, but mediation, that compromised officers' private passion for justice. By entering into deliberations with employers as if their crimes of exploitation were isolated incidents, officers lost their cases from the outset. This case, he says, recalls the main questions the book poses. So it functions as an illustration of the kinds of preoccupations the book has. What are the prospects for human rights to be universal in the actual situations in which they are evoked? Again, I recall that this is an important move. This is kind of an anthropological move with respect to human rights. So the question is not what are human rights as such in the abstract, but rather in the actual situations given the actual practices people undertake. Second, how do historical inequalities influence both the popular understandings and the actual scope of human rights? And then finally, he reminds us that the aspects of human rights discourse at issue in the book, translation, civic education, legal aid, show how universalist human rights concepts can, in practice, take on a highly particular content. He explains. The discourse was universalist, not culturalist, and yet it masked the highly specific interests it served. By making individual freedoms the essence of rights, it marginalized other grounds for making claims. Moreover, by disengaging from the reality of situations, it provided no means to imagine the universal situation of human rights. What the chapter shows is that the institutions that were to consolidate democracy produced instead an illusion of progress, while Malawi's historically deep inequalities persisted, indeed became masked because they were shielded from critical reflection. And frankly, because they became embodied in the interactions, the highly unequal interactions between employers and workers on one hand, and between clients and legal aid advocates on the other, who again had a stake in protecting their status and therefore of not aligning themselves too closely with the workers who they represented. In this section, Hard Work, Little Pay, Eglund outlines a range of allegations that Chikondi makes against Patel, including paying a salary lower than Patel had agreed on, which itself was below minimum wage, abruptly announced long distance and lengthy trips for which Chikondi would not receive an agreed allowance, and indeed would not even be given time to go and get a change of clothes, to let his wife know that he was leaving town for up to a couple of weeks at a time. It was just, off you go. You're going on this trip. And also then of withholding his travel allowance by the driver, so that the driver would be given Chikondi's allowance as well as his own by Patel, and be told to dole out the allowance to Patel. But of course, there was no oversight, no guarantee that the driver would in fact give Chikondi the money that he was obligated to give, the money to which Chikondi was entitled. And so we find through the chapter that Chikondi's sleeping circumstances were absolutely abysmal, that he didn't have enough really to eat properly, and so the the suddenness of these trips was compounded by the stark deprivation that they would also entail, and the just egregious exploitation that was involved in them. Finally, then also, Chikondi raised the problem of Patel withholding pay for the month that he had just worked before he ended his employment with Patel. Now, Patel's criminally exploitative practices had further repercussions for Chikondi, placing his very humanity at work. And I say criminally exploitative because he was actually breaking the law in the way that he was abusing Chikondi as a worker. And not Chikondi only. There were other workers who faced abuse as well. Now, to say that he was putting Chikondi's humanity at risk, it means that he was treated by Patel, and on these long trips into the countryside, also by the driver, as a being whose suffering was simply inconsequential, hardly human at all. Chikondi was not the only employee exposed to such treatment. So through Chikondi, when he testifies to the legal clinic, we learn that Patel had accused two other employees of stealing from him. And rather than doing something like getting the police involved and going through legal channels, he just had his sons beat them with sticks. This was his solution. Eglund argues further that maintaining such abusive working conditions in itself creates a sort of desperation that propels people like these employees toward crime. And we'll find that Chikondi winds up characterizing his predicament, his working predicament, in explicitly racialized terms, anti-Asian racialized terms. But Eglund's point here is that he arrives at these kinds of positions, these positions where he seems to have forsaken a certain humanness or humanity anyway, not under his own steam, but he's propelled into them. And so, were he properly paid? Were he properly compensated for his trips? Were he given adequate notice before going on these trips and an adequate allowance when he was on them and proper living conditions while he was away? Then the implication is that the nature of his protests would be entirely different and wouldn't take on these uh, racist or at least prejudiced um, qualities, that there wouldn't be the inclination toward criminal behavior like stealing if they were properly paid, at least at the minimum wage to begin with. Now, the picture of unskilled labor as subhuman was one that not only Patel held, but also implicitly did the legal officer. This enabled a kind of collusion between the officer and Patel. So it's not that they conspired together. It's not like they plotted something out in a conspiratorial way. But yet there was collusion because of their shared view of unskilled workers in general, of which Chikonde was therefore an example. The less privileged, he writes, appeared as a distinct species altogether, a type that simply did not need or even want all the commodities and services that were at the other's disposal. Now, England doesn't put it in this way, but we could think of this as something along the lines of just class alliance. It sort of has that quality to it. The picture is more complicated than that because, of course, there's the question of a distinction between an entrepreneurial class and a professional class. But the point remains the same in a sense, in that the officers had a deep investment in protecting their status, and their status made them more of a mind with employers like Patel than with workers like Chikonde. Now, along with this dehumanization, there existed both a malevolent and a benevolent variant. For those like Patel, the poor workers deserve to be treated with suspicion, indeed derision, for their failure to advance themselves through education or efficiency. In other words, their worthlessness came from their refusal to lift themselves up by their own bootstraps, to improve themselves through who knows what means. Others, like the officers, saw them as charity cases, so this would be the benevolent face of this. To be held at arm's length, to be sure, to be treated with pity, their misery offering an ever-present opportunity to demonstrate one's high-mindedness. So that if the officers looked on the needy, desperate workers with a kind of benevolent pity, they could congratulate themselves for being high-minded, while at the same time holding those people at a distance. Either way, malevolent or benevolent, either variant paves the way to treat Malawian laborers like children. Eglund shows, though, that Chikonde did not accept this infantilization and dehumanization, insisting on the justness of allegations and his view of proper ways to treat workers. So that he, despite the extraordinarily difficult situation that he found himself in, he continued to insist on the soundness of his view of things, that he would not simply be cowed. The cost of pursuing legal redress for Chikande and his family were substantial, though. He went for weeks and weeks without getting the money that he was owed. And it's not like he had a raft of savings that he could draw on in the meantime. This meant then missing rent payments, eventually getting evicted, experiencing food shortages, and the like. Chikande, bearing up under these hardships to allow the institutional processes of legal redress to unfold, would seem, therefore, to be the exemplary democratic citizen, right? Not the one who takes matters into his own hands, not the one who turns to criminality, but rather the one who embraces and encourages the democratic transition of Malawi by embracing and using the institutions available to him to undertake the proper legal path toward redressing his grievances. Eglund, however, finds the transformation to be nominal, as citizenship conferred political rights alone. So they had the right to participate in periodic multi-party elections, and that's about it. That obscures from view, for example, the view of the civic educators we saw in previous chapters, the persisting relations of power and hierarchy that shape the lives and opportunities of people like Chikande. Again, this is the context in which human rights arise. They arise in the lived realities, the concrete experiences, circumstances, and social structures within which people live. They don't occur in abstract realms. One of the lamentable results of appealing to legal aid is that Chikande was held responsible for defining the heart of his complaints. In other words, he was simultaneously denied the status of one who has the requisite expertise to mount a claim, and he was expected to have the requisite expertise to figure out what was relevant for and what his complaint should be constituted of. The officer instructed him to say only the necessary things, thus placing the burden on him to determine what these necessary things were, as if he came with the legal expertise he needed to discern what in a legal setting is necessary and what's extraneous. Of course, that's the job of the legal officer. A result of this was that officers ignored or remained ignorant of aspects of Chikande's exploitation by focusing only on issues related to his salary, thus undermining legal aid's effectiveness. They sort of hamstrung themselves in a way. So that when a legal clinic officer met with Mr. Patel, his strategy was to show him respect, even deference, rather than challenge him on the abuses of Chikande. Having aligned himself with Patel in this way, again, as I say, not conspiracy, but collusion, the officer went on to treat Patel as if it was their task, the two of them, to placate Chikande, as though he was a problem for the two of them, and it fell to them to collaborate on a way to find the minimum concessions necessary to satisfy Chikande. Right, now, the point that I want to make is that seeking this rapport with Patel, rather than identification with Chikande, sort of ironically misaligns the officer, because, again, it comes back to this idea of recognizing one of a comparable kind of status, Patel, and recognizing Chikande, on the other hand, as of a completely distinct status, one to be held at arm's length, so that the point of identification is much stronger with Patel than it is with his client. We find then this kind of surreal reversal in which Patel appeals to the officer for help, and the officer responds by offering this kind of compassionate understanding of the challenges that he must face as an employer. Chikande, the dehumanized object of exploitation, suddenly appeared to be the source of problems as an employee who wanted to leave, who was free to leave and to look for other employment, whereas the employer as busy to the point of being distressed. The resolution that Patel and the officer reached was only for a small portion of what Chikande had shown the officer he was entitled to get. To conclude the chapter, Eglund reflects on the place of anthropology in illuminating legal and moral failures of legal aid. He says, without ethnographic witnessing, much of the abuse and injustice that he, Chikande, experienced would have been obscured by the NGO's classification of the case as successfully completed, where money spoke louder than laws, and where even the most enlightened human rights activists failed to transcend the historical inequalities of their society, the individualization of grievances, unchained neither the exploited nor the advocates of their human rights. It merely made legal aid a tool of disempowerment. So then, people pursue human rights in real life situations. This is what Eglund is trying to illuminate and demonstrate here. And their proponents remain ensconced in contradictory realities. For example, through their longing for status, identifying with employers rather than exploited workers. And they do this even as they advocate for human rights, so that there's a disconnection between their intentions, between their voiced criticisms of employers or of the government, and their practice. The officers at the legal clinic, like the civil educators in chapters 3 and 4, were influenced by the cultural disposition that the social inequalities of their world fostered. Even as they were poor themselves, legal aid officers found it irresistible to see in status distinctions a divide between adults and children. Even as legal aid could secure some compensation for claimants, the status quo remained unchallenged. Individualizing grievances maintained the marginal position of unions, while legal aid produced the illusion that labor disputes reached orderly resolutions. The result has been the continued pacification of workers in democratic Malawi. And that is it. Thank you, and we'll see you for the next and final lecture on the final 2 chapters of the book.